You have the right to remain silent. We call those rights Miranda Rights. Every single day I'm asked the question, Mark, can we get my case dismissed? The officer didn't read me my Miranda rights. Like most things in the law, the answer to that question is not a straightforward yes or no. It requires a deeper understanding of the Miranda warnings and when those warnings apply to your case. The Miranda warning comes from the 1966 case of Miranda versus Arizona, in which the U.S. Supreme Court ruled that criminal defendants must be advised of their right to remain silent. Under the Fifth Amendment, statements made during a custodial police interrogation are only admissible at trial if the defendant has been advised of their right to remain silent, their right to contact an attorney, and if the defendant voluntarily waives those rights. The Miranda warnings protect the Fifth Amendment's privilege against self-incrimination, which states that no person shall be compelled in any criminal case to be a witness against himself. Miranda applies whenever a person is in police custody and subject to interrogation. A person is in custody when they are deprived of their freedom of movement, and a reasonable person in their situation would not feel free to leave. This standard is often applied during the initial stages of an investigation. In most cases, once handcuffs are used, it's clear the person is in custody and no longer free to leave. However, a routine traffic stop is not considered to be custodial. In the 1984 case of Berkmer versus McCarty, the U.S. Supreme Court ruled that roadside questioning during a routine traffic stop is not a custodial interrogation. However, a traffic stop can easily become a custodial when an officer determines that a crime may be in progress or is in progress, and then the officer must read Miranda warnings. It is important to note that any police encounter can quickly become a custodial interrogation, depending on the context and specific details. Are you in custody because a police officer walks up to you and asks some potentially incriminating questions? At the park? No. No Miranda necessary. You can walk away. You don't got to talk. But what if 5 police officers walk up to you with their firearms drawn and they ask you questions in a polite manner? Well, you are in custody because a reasonable person wouldn't feel free to leave. If a person does not feel free to leave, then Miranda warnings apply. If you've been charged with a crime, it's crucial to consult with an experienced defense attorney to determine if any admissions you made while in custody can be suppressed. And the Marc Lopez law firm can help you figure that out. The bottom line, a failure by the officer to Mirandize you does not automatically result in dismissal of all charges. However, it may lead to certain statements being considered inadmissible at trial, and it's worth discussing with your attorney. If you have any questions about statements you might have made while in police custody, do not hesitate to call us at 317-632-3642. And remember, always plead the fifth.